The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
We are now going to hear from a panel updating the Committee on Electronic Filing in Texas that will include, again, David Slayton from the Office of Court Administration and Martin Zelinsky, the Department of Information Services. Martin? And again, both of you, I guess we'll start over and give your name and who you represent, and we'll start with this panel. And we'll start with you, David.
Good morning again. My name is David Slayton. I'm the Administrative Director of the Office of Court Administration and Executive Director of the Texas Judicial Council.
Thank you, Mr. Chairman and members. My name is Martin Zelinsky, and I'm the General Counsel for the Department of Information Resources.
Thank you. Where are we?
Okay, so just to give you a little bit of background information, in 2002, the e-filing program was started in Texas, whereby clerks and counties could sign up, and appellate courts as well, to establish a system whereby individuals could electronically file documents to the court. That system was set up between in the executive branch with DIR hosting that through the texas.gov portal and contracting with a vendor to do that. In the 10 years since that program has been established, it's been a fairly slow but somewhat steady increase in the number of counties participating, until at this point we have 52 counties participating, and it covers about 80% of the state's population. The system has about 40,000 e-filings going through it each month.
How many?
40,000.
40,000, okay.
The Supreme Court itself mandated e-filing statewide last September. So basically, I guess you could say that it actually covers every county in the state for that purpose. But individual county contracts, it is 52. One of the real difficulties that I'm sure Martin will talk about as well.
Pardon me. Sure. What you just said about individual contracts and
exactly.
I didn't understand what you just said.
Right. So one of the real difficulties is that the way that this has been set up is that each clerk is a customer in this arrangement, and so when there's an agreement that needs to be signed, which is the process we're going through as we speak, then each clerk of these counties has to sign an individual agreement with DIR, and so it's been somewhat difficult. Obviously, one of the things that's really nice about e-filing is that it very much streamlines the court operations, can produce a paperless court, eliminate paper shuffling, as well as reducing the physical storage, which is so expensive these days. It also improves attorney efficiency, and most attorneys are now familiar with doing this if they practice in federal court, as it's mandated in the federal court system. Because e-filing is mandatory in the Supreme Court, it's mandatory in several of the appellate courts, and it's now mandatory in a few district courts, it is technically possible for a filing to begin all the way from initiation through the appellate process without ever being on a piece of paper. So that's one thing that's... Yes, sir.
There are some counties that have been doing e-filing for a while, and then there are some that are evidently bringing online. The ones that have been doing it, are they having to redo their system, or is it consistent with what we're doing?
Well, what we have right now, we haven't changed over systems at this point. We're still using the same system that we've had since 2002.
Okay.
Jumping ahead a little bit, what we're looking at is NIC, who is the current vendor of the system, had indicated to us last summer that they were no longer into the hour, they were no longer able to continue under the current terms and conditions of the contract, and that they wished to terminate that contract at the end of August of this year. Based upon that, we began discussions, issued a request for information, and then later a request for offers to get a new vendor in place. However, because of the timeline of that, we realized that we weren't going to be able to have a new vendor in place by September 1st. And so we asked DR to engage in an extension with the vendor, and DR has done that. The extension is for 18 months, so beginning in September 1st, we're operating under an extension of 18 months into the current system. Once the new vendor which is still in the process of being selected at this point, once that new vendor is in place, sure.
Let me just follow up with the question. The current vendor,
right?
Are all the clerks who are doing electronic filing statewide now under the same vendor?
Unfortunately not.
That's what I thought.
That was the intent originally.
Yeah.
What we have are a couple of counties who were grandfathered in that before 2002 were already had implemented electronic filing, and though I believe there are 2 counties that are operating that system. We also have a very large county in the state who has started up what's called a free fax filing, whereby they can free file through the fax system, and it's an alternative approach to electronic filing.
Electronic filing has a fee attached to it.
Exactly correct.
The fax doesn't.
Doesn't. That's correct.
And is I have heard, and I'm going to say this is Harris County.
Yes.
And is the concern, too, that this fax filing actually may violate
that concern that has been expressed that is a violation of the rules and the agreement that's in place.
And I also just wanted to point out one thing about the extension. The terms are not exactly the same because there is an increase in the filing fees. That
is correct. The extension, we worked with the IR and the vendor to for them to transition past this the August 31st deadline. The vendor has to do a lot of upgrades and, in fact, moving a data center. So there's significant investment of revenue to do that. And so we worked with them and DIR to try to allow the vendor to recover those costs within the period of the extension. One of the ways that the DIR board, when they originally came back, the increase in fee was a 62% increase in fee. Thankfully,
that's why I heard about it.
Yeah, exactly. Thankfully, we were able to visit with the DIR board and the staff over there, and basically what the DIR board recommended and was approved was that the state share of that filing fee, which the way it's set up is there's a state share, there's a vendor share, and that the DIR board recommended waiving the state share so that during this limited interim period that the increase in cost would only be $1. So the filing fee from the electronic filing manager goes up from $4 to $5 per filing under that agreement.
Chairman Lewis.
Thanks. If you would, because I'm really not that familiar, Ector counties, the counties that I deal with aren't always on this system for filing. But in the federal system, certainly in the Western District, everything we file is electronically filed. But to my knowledge, there's not a software vendor we have to deal with. But if you're familiar with the federal filing system in the trial courts, would you compare what we presently have in Texas, the system that you're describing to us, with, say, the federal filing system in their trial courts?
Sure. Thankfully, I'm familiar with the federal system. I worked in the federal system when we implemented that in Dallas, and the CMECF system, which is what their system is called, was built by the federal government, so they own that. There is not I don't believe there's a third-party software involved in that. Mm-hmm. The thing Texas is very unique in the way that we set up our e-filing system originally. We are the only state who has a system where there are intermediates along the way. So, including your materials, but basically once an attorney files it, they file it through what we call an electronic filing service provider. Mm-hmm. That's where you choose a company that.
And I just want to make sure I follow all this. Would that be like LexisNexis File and Serve?
That's correct. That's one. ProDoc. There's a number of entities that have to be certified by the vendor to provide that service. But these vendors then provide that service. They provide additional add-on services to the system. Once it passes through them, it goes through our vendor to then be passed on to the court. It's very different than the federal system, and one of the challenges has been the fee structure along the way. The reason why I believe it was set up that way in 2002 was there was no initial state revenue for this, so there had to be a way to pay for it, and so the way it was set up was what we've referred to as a toll road model, where every time you file a document, it costs you anywhere from $6 to $16. Depending on which one of these EFSPs you choose, it costs you anywhere from $6 to $16 per filing to electronically file a document. That's created issues with implementation and, in some counties, a resistance to a mandate.
Sure.
David, won't this always, I mean, if we continue to go have an intermediary vendor, like we have had and others in these filing services, I mean, we're always going to have a problem, aren't we? If we don't control our own filing system, our own filing software, so it's in essence, it's just part of the Texas state government. We're always going to have some intermediary intervening in this and have to negotiate fees, and maybe they'll withdraw, and maybe they'll stay, or maybe they'll go bankrupt. And are we at the will of these people unless we actually develop our own filing system?
Well, I think obviously the answer to that is if we want to be 100% in control of the fees of the system, we need to own it. The problem is the cost to develop, and more importantly, the cost to support the system is extremely high, because you've got all the 90,000 lawyers in Texas, and plus all of the self-represented litigants out there who may choose to use it, and who do they call when they have a question about how to use it, all the upgrades. So we've looked at that. I mean, currently under the way that it's structured, it would be extremely difficult to build one, but yes, the answer to that is true. The way that we can mitigate that is that we can see if there's a way to provide one of these EFSPs at a very low cost, so that filers could actually just skip through that. One of the things that we do have the most control over, and one of the things that we'll be coming to you and talking about in the next session, is the cost of the EFM. Right now, that cost is the $5 fee that Representative Davis was talking about. Starting September 1st, that will be $5, where we control that based upon our contracts. So that's the state side. If we go to a new vendor, we're also going to have to deal with that issue. But if we could instead change from a toll road type model to a perhaps either general revenue to fund that piece of it, or to go to a per case fee instead of a per filing fee. So, for instance, we've estimated that perhaps a $5 filing fee in a civil case, and extending that to the criminal cases for e-filing as well, a $2 court cost would fund the system, where that if that fee was paid right up front, then from there each individual transaction doesn't have an additional cost other than the EFSP piece. So what we're working on in our new contract is how we can provide a method for filers to get through at a very low cost. But that's the challenge we're struggling with because of the fact that it's not state-owned.
Well, it costs either way you do it, right? I mean, you're saying, well, if we go through it and the state does it, we have a cost, but there's a cost now, and there has to be a cost if a private entity is going to do it, right?
Right. Of course, the cost is not borne by the state; it's borne by the users. But
either way, I mean, if we pass that on. Let me ask this, and I don't want to dominate the time, but is there a state judiciary with an electronic filing system that is a model for people to follow, a model for us to look at? Is there like one state or two or three states that they are doing a really good job and have a very efficient electronic filing system?
There are a number of states using this. I think your model of the federal court is a very good system because of the fact that there's no additional charge to use that, and they generate their revenue to pay for that through the document search end of it. There are a number of states that are doing it, but many of the states are actually doing it the same way we're doing it. We don't have none of the other states have the EFSP intermediary, but Texas, in its way, when we originally set it up, put that in. And interestingly enough, a large percentage of our users choose the most expensive EFSP because of the service levels that they provide. That's just firms and attorneys choose to want to use that system. But there needs to be a way that for someone who is a self-represented litigant or a lawyer that's wanting to file and not have these higher fees to have a choice in that matter. So that's something that we're having to work through right now.
Thank you.
But the higher fees don't seem to be repressive. I mean, $5 that's not. And again, somebody's going to pay for it, either the user or the taxpayer. And, I'm the non-lawyer up here, so let me tell you, the taxpayers don't want to pay for it, and we won't tell you the user pays for it. But beyond that, what the concern I'd have, and I think the judge touched on this, is that we own the software. We can do an RFP for a vendor to come in and operate the software. The problem is, if they own the software, if they say we're going, they take the software with them. And so I think ownership of the software is an issue. We need to, if we do a new contract and somebody develops a system, we need to make sure that if they decide to leave, the software is ours.
And obviously that's the situation we're in as we speak, where the vendor is leaving, and we will, if the extension wouldn't have been granted, then we would have had no software. So e-filing as it exists would have gone away. We would have the data because that's in the contract where we would maintain the data, but the contract, the software was not ours.
Representative Davis, you have something?
Well, obviously the first thing I'm going to do after this hearing is go start up an EFSP company.
Can I buy stock?
Yes, you can. I just want everyone to understand just how many different systems. I mean, is it fair to say within a county you can have each court operating on its own sort of electronic filing system?
I think the answer to that is no, because the clerk would control what the system is that's being used for electronic filing. Technically, there could be two. Granted, I will say that since 2002, there have been no new electronic filing models. If you don't count the Harris County model as electronic filing model, there have been no new electronic filing models that have gone into place. It's just those two counties that have been grandfathered in, so to speak, under the old model that have. They're still on different systems, but generally, the problem is we have many counties where the district clerk will accept electronic filing, but the county clerk doesn't, and so it's kind of right now it's a real jumble. I included maps so you can kind of see all the different counties where it's being used.
In Harris County, that generally operate on ProDoc, I believe, for electronic filing, but then we have the asbestos MDL court that's LexisNexis. Is the file and serve, is how you file and serve. And I know we're talking about the cost, but I think it's important to consider access, because I am a lawyer, so it's easier for me to figure out how I need to file and serve something. But when you're talking about someone who doesn't have a lawyer, how are they supposed to know how they're supposed to file something? I think it is important to have a centralized mainstream way so that everyone has access to the courts.
Sure, and our goal with this new system is to ensure that there is a statewide unified system, that your password and your username to file in Lubbock County, Loving County, or Harris County is exactly the same.
We talked about this yesterday. We mentioned Loving County. This all makes sense in Dallas County or Harris County. If you're in Loving County and you have 3 cases a year filed, it may not make sense.
Sure.
Simply because the volume doesn't, and for 2 reasons. And I said this tongue-in-cheek yesterday to you that first, just the volume doesn't justify the investment. But secondly, the good old boys in Loving County probably don't want a Dallas lawyer filing cases in their county anyway.
I think what you point out is there's 2 sides to that. If it's a voluntary system, maybe it makes sense for those counties that want, even in Loving County, to choose to allow it. When we start looking at a mandatory system where the judges, or at some point the Supreme Court or someone else decides to make it mandatory, that may be where the distinction comes into play of, is it really worth making every filing in the Loving County, for instance, to have to be e-filed versus in some more urban jurisdictions?
I believe in technology, but there are times when a big chief and a number 3 is more efficient than technology. We need to view that. But I would think, and we talked about this yesterday too, that there are probably levels of, it should be mandatory with courts up to a certain level, and then maybe as you move down, you start at the top and move down, and the ones with the least filings come last in the pecking order. Chairman Madden.
Thank you. How does this work? I have a few people that I deal with on corrections called prison lawyers.
Yes, sir.
That do lots of cases, lots of filings. How does this work?
Well, for
those that are in the habit of filing significant numbers of cases, many of which may be in fact be frivolous. How does that work?
The fact is, if the location where that prison lawyer is has an internet connection, I guess they could use electronic filing.
No, they can't. They're not supposed to. Let's put it that way. They may have other people who would do it for them,
sure,
but they cannot themselves. Okay.
There will obviously always have to be a way to accept filings manually, because there may be individuals who do not have access to internet or the literacy to do so. There's been some discussion about in those cases that there would be a courthouse where someone could still come to the courthouse, uses the...
We don't always allow these people to go to the courthouse.
Well, not those individuals, but individuals where those could just be filed the way they are now through the mail, and then of course they would be converted to the electronic side once they got to the courthouse.
Who pays for those?
Who pays for the... Well, the one thing is the system that we have now, as well as the one in the future for government and indigent filers, is a no cost.
Okay.
Any other questions, David?
Don't think so.
We'll hear from Mr. Zelinsky.
Thank you, Mr. Chairman and members.
Zelinsky?
Yes, sir. Martin Zelinsky, General Counsel for DIR.
Okay.
I've provided some written testimony to this committee, and many of my remarks are going to be repetitive of what Mr. Slayton has said, but perhaps from a different standpoint. So I'll just highlight some of those remarks. Today, e-filing is used, as Mr. Slayton said, over 40,000 times a month, benefiting filers, judges, courts, and clerks. It is a secure and efficient system that assists in keeping many Texas courts running smoothly. The e-filing program has generated several efficiencies, including reduced storage costs for courts based on the elimination of paper records, reduced administrative costs, automated and streamlined business processes, no-fee services for indigent and pro se filers, and no fee for appellate and Supreme Court filings. And all of the project development and ongoing program operations are performed at no direct cost to the state. However, after many years of operations, we still have challenges. E-filing has not yet been adopted by most courts in the state. The slow adoption rates have adversely affected the program's ability to recoup the initial investment and financially sustain itself. Ongoing operational and support costs remain high. And finally, the program's technology infrastructure has become outdated over the years. The current e-filing contract, as was mentioned earlier, is nearing expiration on August 31st of this year. Despite the strengths of the e-filing program, the challenges that I mentioned are largely unresolved. Given that the current agreement expires, the Office of Court Administration requested an up to 18-month extension of the current system. To ensure that the current system can support current and projected capacity demands, Texas.gov must upgrade its infrastructure platform and migrate software to a new data center. This migration and upgrade is currently underway. Because of these additional costs, Texas.gov, in collaboration with OCA, requested DIR board approval of an administrative fee increase for non-indigent filing fees. The following fees were approved effective September 2012. The e-filing fee was increased from $4 to $5 per filing, and the optional e-service fee was increased from $4.50 to $5.50. The Office of Court Administration, our vendor, Texas NIC USA, and DIR are currently executing a communication plan to inform all jurisdictions of the extension, the infrastructure upgrade, and fee changes. All extension preparations, including the infrastructure upgrade and the execution of approximately 50 customer agreements, must be completed by August 31st. The extension that goes into effect September 1st is an interim solution to be able to continue e-filing successfully. In closing, a consistent enterprise-wide approach is important to better position statewide e-filing for success beyond the extension. Such an approach should include these three elements: consistent enterprise policies and requirements developed by a central owner of the system, minimal customization across the various court systems, and standard requirements for documents, metadata, rules, reports, fee structure, and audit processes. DIR remains ready and available to assist the judicial branch in any way possible during the transition period. That concludes my remarks. I'll be happy to take any questions.
When you say a central owner, I assume you mean the state.
Yes, the state, but also within the state, one central voice for specifying business requirements.
Yes. Okay. Any other questions? Chair Lewis.
Mr. Zelinsky, Mr. Slayton kind of dealt with this a little bit, but let me ask you, what would it amount to? What would it take for us to get the state to take ownership of a system, develop a system where, in our district courts at least, maybe non-domestic cases, but our district courts, that the public would have the ability and the efficiency to file electronically, to file their lawsuits electronically and their pleadings electronically, and we could experience the savings that electronic filing has over paper filings and the management of paper filings. And instead of paper filings being done, then they go convert it to, the clerks have to go convert it then to electronic. What would it take to do that? What would any idea of the cost to do it, and then what it would take to do it, and can we do it in 18 months?
I have no idea of the cost. There are several approaches that one could take to do what you're discussing. One would be to have your own programming staff to write software code and develop a system from scratch. That would be fairly expensive.
Now, let me ask this. Do you have to develop the system from scratch, or are there systems that could be purchased by the state from states that, if there are any that do it right, to do it right with the federal government?
Well, and that
in other words, can you buy these things rather than sort of rent them like we're doing?
I actually think OCA will have better insight on that than I will, because their RFO is headed down that direction. Because the next alternative to writing your own code would be to find something that's sometimes referred to as off-the-shelf software, COTS, customized off-the-shelf software. If there is such a system that is available, and I know that there are some that are available as services, but again, you still would not own the software. You would simply license it from those who provide it. And the third model, which we have used in Texas.gov, is to have a vendor develop something for you. In this case, it was actually developed as an application that the state would have owned, but was converted into a service, software as a service, several years ago in order to keep the cost impact down. So there are several models that one could take, but I understand your appreciation of the important distinction of not being held hostage and being able to own what you have and being able to continue it. There will always be a cost at some level.
Yeah. Well, I guess we've got that, and then you've got, just look at this map, I mean, the dark parts of the counties you can electronically file, and then everybody else dealing with most of the state geographically, not population-wise, but most of it don't have the opportunity to do this yet.
So. They do have the opportunity. The system is available in all counties and to all courts, but many courts, and even within the counties where some courts are using it, other courts are not.
Right.
But the system is frankly readily available, and I think there was a question earlier about how does one actually do e-filing. If I'm an attorney, you actually don't work directly with DIR or our vendor. You work with those EFSPs, and the list of EFSPs is readily available, and their website. You go to their website, all you need is a name and a credit card, and you're up and running. Now the courts, then, it's a different process for them to be able to use e-filing within their system, and there you run into some of the issues. Some courts may not be proponents of using technology within the courts. Others, it may not be compatible with their case management system, and that's actually a bigger problem, I think.
Thank you, sir.
I I have a friend who's a supervisor in the district clerk's office whose job is, with his crew, is to put all the cases online so he can dispose the hard copy, which is, we could do away with all that by just doing it up front. But
that's certainly our hope.
Have we looked at other states?
Yes, we have. We've engaged again. I mentioned the National Center for State Courts earlier. They are kind of the repository of all this information. They have helped us along the way. In fact, they even participated in our RFO review and provided us some input along the way. There are a number of states, once again, that are doing this. Most states are not building the software themselves. They're doing it software as a service. In our RFO, we did not receive any bids from anyone wanting to sell us the software. It's all software.
Well, even if you license the software, I mean, that's something that's permanent. It's not like the vendor walks away, you walk away with your license. You license it yourself, then somebody else might operate it. But any other representatives?
I just think the situation that we've been discussing with NIC really shows us how important it is that the state maintain or have control over the system, because when I was first learning about this, and it was this, what was the 63% increase in fees, and what was the state going to do?
Right.
We were kind of over a barrel with that because that was the only vendor and we hadn't received. So I think that this is a really good time to talk about it, given what we've just been going through.
And if you got all the state, if we had all the state, or at least all the major courts in Texas, all the major counties, clerks in an electronic system, and then your vendor walked out, you'd be in a heck of a shape. I mean,
Mr. Chairman, let me show the other side of the story.
Okay.
So there is a second side of this too. If the state does it, the state then has to make sure it's maintained and processed and updated and kept up, and there's a significant cost associated with that. And I will tell you, I have such a system at the Texas Department of Criminal Justice that is certainly well behind times and doesn't have the capacity, and there are things that you can get yourself into just as badly on the other side by taking it on all yourself. And so it has to be done, whatever it is, it has to be done correctly with the right kind of controls and the right kind of processes. I commend the guys for the way that they've processed so far rationally, and just say that we have to keep that kind of.
Well, it could be a hybrid, though, where you were the licensee as opposed to the vendor.
Absolutely. The licensees, at least there's a control there. At least there's a standardization. Whereas if you build it yourself and you do the software yourself, that standardization is only unique in whatever you've done that day. So, it's a different kind of problem.
Okay. Any other questions, these witnesses? Appreciate you coming today, and some of these folks will be working on this in the future years, and I wish you luck with it.